Susan Tomaine is a partner at Blake's and also a member of the firm's executive committee. She advises public and private companies with respect to corporate finance transactions and mergers and acquisitions, as well as on corporate governance matters, securities compliance across a wide variety of industries. Stephen McKoen is also a partner at Blake's. His practice emphasizes domestic and cross-border mergers and acquisitions, reorganization, corporate finance, and corporate governance. He has to support a wide variety of issuer, underwriter, and private equity clients in a variety of sectors, including high-tech, health sciences, mining, and forestry. So both Susan and Steve have diverse practices, but they have significant experience representing public companies with respect to security transactions and security compliance. And that is what they will largely be talking about today.
Thank you. Can you guys hear me okay? Do I even need this? Is it helpful?
Yeah.
Oh, thank you. Okay.
Test.
So as we upload our slides here, I'll just say a few introductory comments. Thank you for the introduction. Steve and I both do have very diverse practices, and we'll talk a bit about that today. When we refer to securities law, the way I describe it, if you were sitting in my office, is, that just means that we're business lawyers that need to know the big book and not just the little book. So I don't know if anybody is familiar, has taken any sort of securities legislation, but the act is the act and all the instruments are voluminous. And so, what distinguishes being in the securities group of a law firm from any of the other corporate groups is it does mean that you need to be able to navigate the big book, which is, not to say anything against my corporate colleagues that just have to know the little book. So Steve and I
Not
both
directly saying anything against them, just, just kind of a bit of shade.
Steve and I both have started our legal careers at different firms working in the U.S., so that's kind of provided a bit of kind of diversity in the background, and I think is part of the reason why we have the breadth of practices that we do. We both worked for New York firms for several years. I came to Canada and Vancouver as a fifth-year associate, and having worked in London and New York, which was a great experience, and then joined Blake's at that time, and I've been at Blake's for 15 years now, which means I've practiced for 20 years, which makes me feel very old, but it's true. So we, as Cam said in our bios, we both predominantly practice corporate finance, mergers and acquisitions with public companies. And that's the public company aspect is what brings us into the securities law realm. So, starting with the public company aspect of what we do, public companies are ones that are widely held and listed on a stock exchange. In Canada, we have the TSX, and we have the Venture, and also the Canadian Stock Exchange, which is much smaller. So there's a whole regime of rules that govern how you have to behave as a public company. The rules are there to protect the public, right? Because any person can go on E-Trade or whatever your platform is, look up information that's publicly available and make investment decisions. And so the securities law regime is really designed to bring some certainty and uniformity to capital markets activities so that people are properly, there's all your email too, to really protect the investing public. And so it provides a number of different regulatory regimes in terms of public disclosure, required approvals. There we go.
All
A
right.
day in the life.
Good to go.
Okay. So why don't we flip forward and I can see what I've skipped. And I should have also said we would love to have questions as we go. Happy to make this as interactive. I know different people have different levels of experience with what we're talking about. So there are no dumb questions. Please jump in.
Just use the arrow buttons.
Okay, so we've talked about the fact that we're mainly in the realm of public companies when we're talking about securities laws. I've mentioned corporate finance, and when I say that, I mean going and getting money. The capital markets are a place for public companies that comply with all of the regime to go access money from the capital markets. Mergers and acquisitions, buying and selling, there's a whole set of securities rules that provide how you implement an acquisition transaction, and also all the disclosure that you're required to put out there, and what the approvals that you're required to get when you're in the public company world. It also includes commercial contracts. There's securities law aspects and considerations if you're a public company and you're entering into material commercial contracts. And I think one thing we'll talk about here as we kind of talk about how we work with clients, just because you advise on securities laws, as you understand that client's business, sometimes you end up assisting them in commercial arrangements as well. Securities, this is very 101, is not PPSA, thank God. Article 9 was the worst class I took in law school, and I am not, while I have utmost respect for my banking law colleagues, that is not my expertise. It's not lending or granting a security in property, so we can all have a philosophical discussion about when a loan becomes a security, but generally speaking, we're not doing bank loans. We can advise on some aspects of lending transactions, but when you're talking about securities, you're not talking about financial services. You're not talking about asset-backed lending. You're not talking about derivatives or other types of mortgage financing. Not talking about cybersecurity, although it's very important, and all of our public company clients have all sorts of challenges with that. And it's also not about how you feel. Public company.
So we're not going to join the trainer call. What is a public company? As Susan was indicating, a public company is a company that, at its base, has done the things necessary in order to access the capital markets. But the rules that apply to public companies are like a coral reef. They've just grown up over time. And if you go back to the 1700s in the UK, which is where a lot of our structures come from, the way that you would raise money is literally in a coffee shop. People would go to a coffee shop, they would all hang out there, they would talk about ventures they wanted to finance. Lloyd's of London, Lloyd's was a coffee shop. That's why it's called Lloyd's. And so they would go to these places and they would hang out and they would say, I've got a venture that I want to finance. Would you like to engage in it with me? And if you can get enough people together who are willing to go and finance your venture, you would have a company of adventurers, which I find very romantic. And this is the language that talks about the formation of one of Canada's formative public companies. This is the Hudson's Bay Company, where John Fenn and John Portman were the original promoters, and they went and created this society and got an act of the British Parliament, that's the act there, Charles II, by his grace, did the following, and created the company. At that time, in order to create a company, and you guys have taken your corporate law. Cam, I'm sure, has taken care of that. The reason you want to have a company is you want to create a artificial person, a bundle, a place, an envelope that you can put liabilities in, you can put obligations in, you put assets in. That's what a person is at law, at least this kind of law. And you want to create an artificial one of those. Well, you can't just do it. You can't just snap your fingers and create one. You've got to have some legal basis for it. And for the longest time, before the UK had a Companies Act, you needed an act of Parliament to create a corporation. And that's what this act is it creates a corporation. Things have gotten a little simpler now, but that is the basis for all of this. Oops, I clicked off that when I was... So, what is corporate finance? So both Susan and I mostly these days work with equity capital markets, but there's also debt capital markets. These are places where you can go and raise money. Instead of going to a coffee shop, now you call up a banker, and the banker knows the people to talk to, and they know the folks who are interested in investing, and they can round them up and help you raise money for your venture. If you want to have as many people as possible able to invest in your venture, you have to do what's called a public offering, where you put together a document called a prospectus, where you tell the entire world about the risks and opportunities that are inherent in your venture, and then they can make a determination as to whether or not to invest on the basis of the disclosure in the prospectus, and off they go. But we also help with private placements. So securities lawyers aren't just dealing with public offerings. We also do private placements. If it's a private investment in a public company or a public entity, we call it a PIPE, a private investment in public equity. The idea is that you can go and have a private placement by a public company as well. You don't have the prospectus. The person gets it subject to certain restrictions called hold periods, et cetera. They have limited disclosure that's given to them, but typically they're what's called an accredited investor, which means they're large enough that they can kind of look after themselves. They have the negotiating ability to look after themselves. So you might negotiate a private placement with them. But it might be a placement of equity, it might be a placement of debt, it might be a placement of convertible securities. All of these things constitute corporate finance. And so when companies need to raise money and they don't want to go and borrow it from a bank, they'll go to the capital markets. Why would you make that choice between the banks and the capital markets? Typically, the capital markets money comes with less strings attached. Typically. There's a whole world called high yield debt where a very, very brilliant crook named Michael Milken invented a world of being able to do public offerings of debt, which had a whole bunch of strings attached, but we don't even get into that. Typically, the stuff that's on the public side has less strings, which means that the company has more flexibility, and more ability to go out and do stuff with the money. Whereas the bank is going to be over your shoulder all the time. They're going to want you to maintain certain ratios in your finances. They're really going to be constraining your behavior. And you don't want that sometimes, because banks aren't flexible and they don't move very fast, and they can be a real pain in the ass to get consents out of. And if you don't want that overlay on your business, you're going to look elsewhere for your capital. In British Columbia, in all jurisdictions in Canada, all offerings of securities require either a prospectus or an exemption. Our colleagues in the private company group, they don't think of themselves as being involved in securities transactions. They think that's our world, but they are involved in securities transactions. They just tend to use the same exemption over and over and over again, the private company exemption. But still an exemption that's available, and that means you don't have to do a prospectus. So if you want to start your own company, because you and two friends have got a great idea, you were at a hackathon this weekend and you came up with some great app and you're going to go out and monetize it, and you want to start a company, and you decide that you just need 50 grand, but that's okay because Mary's dad has 50 grand, and so you go to Mary's dad and Mary says, okay, I want some shares for that. You just offered shares in your company to Mary's dad for $50,000. That's a securities offering. There is an exemption for that, but you have to have an exemption or prospectus. We do a lot of public offerings. That's where people kind of come to us. And there's all sorts of different flavors of public offerings. We talk about long-form offerings, short-form offerings. We don't need to get into the details of that, though. There's rules that apply to the prospectuses that you're putting out into the world. And if you've never done one before, you have to have a whole bunch of information in it. That's a long form. If you've done a bunch before, you might be eligible for short form prospectuses, which have a lot less information in them, though they incorporate information from elsewhere. That's part of what we do on a day-to-day basis. You also interact with exchanges, because buyers, while having technically, you don't have to be listed on exchange for your shares to be free trading. If you don't have somewhere with an established market to go and trade the shares, then doesn't do you a lot of good to have free trading shares. Like free trading debt typically isn't listed, and so it only trades in what's called the upstairs market. You actually have to phone somebody and say, hey, you want to buy some debt? That's a very illiquid market because you got to find people who are willing to trade. They're not really willing to trade in tranches less than $2 million in size, so it's not it's a chunky market. And so it doesn't work as well as the equity capital markets because the equity capital markets have these facilitators called the exchanges who list the securities and will say, this person's willing to sell for this price and this person's willing to buy for this price. And if those prices match, they'll trade.
I think we can, oh, yeah, go ahead. It might be, can you go back one slide?
Sure.
Just to talk about like, the role of the lawyer here. So when we think, I'm just thinking, this is a day in the life of a securities lawyer. So, I mean, number one is knowing the rules. So Steve described the regulatory regime, knowing the prospectus exemptions, knowing what a prospectus looks like, knowing how to draft it, how to do due diligence, how to keep everybody on side out of trouble. That's kind of like step one is you have to know the act, you have to know the rules. The other area where lawyers are value add here is with our relationship with the regulators. Like in addition, we don't interpret the rules on our own in a vacuum. There are guidance and we actually work with the regulators in the application of the rules. So knowing how to advocate for your client without, while at the same time building constructive relationships with regulators at the commission or at the exchange so that when you do work through problems and your issue doesn't fit squarely within the rules, you are seen as someone who's going to be thoughtful and creative and constructive in navigating that. Because sometimes, not surprisingly, the people that go into the room and write the rules, when you come out and apply them in real life, it doesn't always fit perfectly. And then the other aspect that I'll mention in terms of the lawyer's role and where they can be value add in corporate finance is understanding how the deals work in your client's needs. And by that, I mean, on the public company side, when you're first doing your first deal, you're not necessarily going to fully be able to anticipate the pace of it and the timing of it and all the intricacies. But a good lawyer understands not just the rules, but how to support both the banks that are out there finding people to write checks and the issuer who are speaking to their investors and their shareholders trying to build relationships actually want to execute. So things like knowing that when you launch, if your deal is a bought deal, that if you launch the bought deal, that everything, you have to be on deck with your signed bought deal letter and press release ready to go at the moment the market's closed, because the bankers are going to be on the phones trying to catch everyone, all the traders, before they go home. So you can really be very unpopular with the bankers if you don't have your shit together and know you've got to be on deck, everything's got to be done. They've got a 30-minute window to catch everyone before they go at the traders at their desk before they go to the pub, and that's when they have to sell the deal. And so you have to be not just, why are they being so stressed out about timing? You have to understand things, like how things actually are executed, so that from a lawyer's perspective, you can be constructive partners with everyone's working on the deal.
It can be a really stressful environment because in a bought deal, for instance, if you've got a $50 million bought deal, that it is what it sounds like. The bank who's organizing it has bought the securities. So they now have a $50 million exposure. And they don't want a $50 million exposure. And nobody internally at that bank agreed to be long those shares $50 million. That's not part of their investment profile. Instead, what they need to do is lay off that position as quickly as possible onto people in the marketplace. And that's why there's so much stress, because if they, at the end of that half-hour period, have anything left on their books, the next morning they have to answer to their bosses as to how the hell that happened. So they really are under a huge amount of stress to get it done. And if you take an extra 10 minutes to get everything filed, they lose their minds, because they're sitting there on their hands waiting for you to tell them it's good to go for you to phone, because they can't do anything until you file. This is just a picture of a prospectus. I'm not sure, I can't remember why we put this on there. This is an IPO prospectus. It's a long form prospectus. So it says initial public offering in the upper left-hand corner there. This is the initial public offering of Thinkific. Prospectus talks about, as you can see on here, it talks about what you're doing. In this case, an initial public offering is exactly what it sounds like. It's the first time you've sold to the public or offered to the public shares for sale. And so they've offered 12,310,000 subordinate voting shares, which are a thing I'm not going to get into, and they're asking $160 million for those 12 million shares. So this is the offering document. There's no sales yet. This is the marketing document you're going to go off and sell on the basis of.
And it's, 100 more pages after that.
Yeah, so much fun.
And we put it in because it was 2021 and everyone was doing IPOs and we were having a good time.
Oh, that's right.
And then 2023 came.
Yeah, exactly. Go look at Thinkific's share price. They aren't getting 160 million for 12 million shares anymore. M&A.
M&A. So, I talked a little bit about the role in a lawyer in corporate finance, and I find it to be execution driven, and the less everyone has to deal with the lawyers, the better. It means things are going smoothly. You're just in the background making sure everyone stays out of trouble and it all happens easily. M&A is a bit more of a strategic transaction, and I think we both probably have more fun on the M&A side. Because M&A, you're buying and selling, and you actually have a counterparty that you're negotiating with. It's, I'm just looking at to see what we've actually described M&A as. It is pretty simple as, one company buying another, or mergers of equal transaction. When you have two companies that are of similar size, sometimes it's important to call it a merger of equals, so that no one's feelings get hurt.
Some mergers of equals are more equal than others.
Yes. And it's like, that's from the very beginning. That's one of the very first dynamics is this an acquisition where one company is buying the other, and i.e. you're paying a bigger premium and your board is staying intact and your executive team all are the ones that have the job on, after closing. Whereas if you're the target company, your leverage is different because you're assumed that your executive is going to be moving on. Your board may not, maybe you get a board seat in the new company, but it's a very different dynamic. Where it's a merger of equals, you're more likely to have a tighter premium, which means the shareholders of each company don't necessarily receive a big bump in their value, but the value proposition is that you're investing in a combined company with a stronger balance sheet usually. So that's kind of one of the very first dynamics. The consideration that's going to be paid can be shares. If it's shares, you have to go through a process. It's very similar to a prospectus, and that you have to put out a bunch of disclosure. You have to make sure that there's disclosure about the shares of the company that's issuing the shares for consideration. Or it can just be straight cash, which simplifies things because it's very easy to describe cash and its value. Or it can be something else, a CVR, which is a contingent value receipt, which is some sort of contingent consideration where you get a security that maybe pays out in the future depending on how the business does. Those are harder and less popular, and we usually... They
never pay out.
They never
They're almost always illusionary.
It often comes up to bridge the gap, bridge the value gap between the buyer and the seller, and then by the end of it, everyone realizes it's so complicated and uncertain, and they're not
Huge
getting
amount of
any
work.
credit.
Huge amount of work. So it's great for lawyers.
Yeah, great for lawyers. Excellent. I totally agree with that. Wow, that's tiny print. So fundamental transaction documents in an M&A transaction. This is where the lawyers pick up the pens. Excuse me. Share purchase agreement, asset purchase agreement, plan of arrangement. So these are transactions that you'll learn about in business corporation. So in the public company context, we're usually looking at an arrangement. I don't know if you guys have had business associations and know what a plan of arrangement is, but when you have a public company and you think about it and it's got hundreds and hundreds of shareholders, you can't go to every shareholder and say, would you like to sign this agreement and sell your shares to me? You can, but that's a different type of transaction. So instead, the company enters into an agreement with the buyer and says, we agree to put forward to a vote to our shareholders this transaction where they're going to get the consideration that we've negotiated. and we'll go hold a shareholders meeting, and whoever comes and votes. And if it's approved by the shareholders and we do all the other things that we say, then we can proceed with a court hearing, go to court, say the shareholders support this transaction, the company supports the transaction, the court blesses it, and you actually get an order that says, by operation of law, under the corporate statute, all the shares that are held by the hundreds of public company shareholders are automatically transferred to the buyer, and all those shareholders have the right to receive is whatever the consideration is being offered. So that's how we technically get a public company transaction done. In a smaller context or a private context where you actually can go and access all the different individuals, then you're going to have a share purchase agreement, and you're actually negotiating directly with the shareholders of the company, and you have to get that selling shareholder group to all agree to the same terms and enter into an agreement. Let's see, what else do I have here that I can't read? We're speaking in the context of friendly transactions. There are ways, Steve will talk about hostile takeovers, but generally these are transactions where if we're talking about a situation where it's a buyer and a seller, they're motivated parties, they've decided that they want to do the deal. Many times these days what we see is the smaller company is willing to be a seller, either because capital's really expensive right now, so to the extent they need to go raise money, that is a lot harder and more expensive than it used to be. Or perhaps the bigger company has a bigger distribution platform, or there's some other strategic driver that makes the parties, willing to come to the deal. And so if you start with motivated buyers, it's a very constructive process. It's why I like it better than litigation, because people theoretically all are trying to achieve the same goal, but that doesn't mean there's not a big laundry list of things to negotiate in an M&A transaction. And that's kind of where lawyers, again, can be value add in M&A, because you're thinking strategically, you understand the deal dynamics, you understand what's going to be important. There's value, obviously that's the easy one, but then there's what are people's roles going forward, what are there any post-closing liabilities. There's a big laundry list of things that we get to dig into and help our clients achieve what they're looking for in the transaction.
One thing before we switch slides, you'll notice that there's a combination here of things that are appropriate for private company deals, some that are appropriate for public company deals. Sometimes you'll do a plan of arrangement for a private company. Susan and I both in our transactional practice do both private transactions and public transactions, because often you don't know where a company is going to end up. Companies get their capitalization from all sorts of different sources. Maybe they're getting funded by private equity. Private equity usually has a time horizon on their money and they want to exit, which is great for us because we think, maybe an IPO is at the end of it, and that's our skill set, and we make a lot of money on those transactions, and so we love doing that stuff. But maybe the market's turned like they have right now, and you can't do an IPO to save your life, but the PE fund still needs to exit because their own investors are expecting their money back, and so they have to sell the company, but it never managed to go public. Well, then you do a private sale. And of course, as we're getting clients and as we're working in the marketplace, we will be making relationships with companies at an earlier stage in their cycle, and then a middle stage of their cycle, and the end stage of their cycle, and they may end up doing a private deal. They may never end up going public, and you need to be able to pivot and have in your toolbox the tools needed to do any of those kinds of transactions. So we do both public and private transactions all the time. There is, as Susan said, there's another thing you can do in the public world. This also applies in the private world, though rare in the private world. Hostile takeover bids. And a hostile takeover bid is a transaction where it's not that mutual coming together of two parties on the other side of a transaction who have common goals and common desire for a shared outcome. Rather, you've got a target corporation that doesn't want to be sold, and you've got somebody who wants to buy them, and the person who wants to buy them says, screw it, I'm not going to negotiate with this board anymore, I'm going straight to the shareholders. And so what they do is they make an offer straight to the shareholders and say, your board has, well, who knows what they're going to say to the board, but they'll say to the board, the shareholders, we want to buy your shares, we're willing to pay you X, you should sell to us. And there's a regime in Canada for how you do that. And there's been a lot of changes to that regime over the last 20 years because of a whole bunch of stuff. Because when you're in a hostel, the person who's the target of the hostel isn't necessarily on board with the transaction and wants to, defeat it if they can. Of course, they'll never say they're trying to defeat it because they have fiduciary duties and they're never going to defeat a transaction. One of our mentors used to always say that there's no such thing as a hostile takeover bid. There's just a hostile price. And so so you're trying to get that price up. That's what you're saying. Now the reality is you may have an entrenched board who is fighting it only because they want to keep their jobs, humans. But that's not how they're going to express themselves, and that's one of the interesting things about the job we have is that you're often in boardrooms where very contentious things are being discussed, and you have to fine-tune your radar for human interactions and try to figure out what they're actually saying to you. When they say this, they don't mean this, they really mean this, but I think they're saying this. And you have to really pay attention to that stuff because it can turn around and bite you when they seemingly pivot and start doing something else. No, they didn't pivot. They're just now being honest about their intentions. And that kind of stuff happens all the time. It's a very dynamic interaction when you're dealing with boards in tense situations, which is part of why this job is a lot of fun. So in a hostile transaction, though, the bidder makes a bid. It gets public. It has to stay open for 105 days. There's all these rules. Unfortunately, they made the change to the rules in 2016 that made it was supposed to make hostile takeover bids simpler in Canada. It used to be that a bid had to be held open for 35 days, but then the target would put in place what's called a poison pill, which would be something that would issue a whole bunch of shares in an explosion of shares to the existing shareholders if the hostile acquirer was successful in acquiring those shares. And the way that works is you make an offer for 100% of the shares of the company, you get 100% of the shares of the company, but before you can pick them up, 9 shares are issued to every shareholder for every 1 share they have. And so you just buy the 1 share off of them and they have 9 shares left over. And suddenly you just paid full price for the company and only got 10% of the company. That's a poison pill. Poison pills were regularly struck down by the regulators in Canada. They didn't like them, but they knew that they had a role in giving a target company time to go out and find a white knight or somebody to come along and help them get a better price or do something they're more in favor of doing. So they allowed them, but they would strike them down after a certain period of time. And something like 75 to 100 days is how long you could have your poison pill out there. And probably more like 75. And they got to be so routine that every time there was a hostile, you'd put the poison pill in place, you'd wait 70 days, you'd go to the commission, it would get struck down, and it would just over and over and over again. The commissions eventually said, why are we doing this? Why don't we just say, fine, all bids that aren't friendly have to stay open for 105 days. There you go. No more need for poison pills, because that was the effect of poison pills anyway. The problem is that because of that, the hostile takeover bid market in Canada has dried up because you have to be fully financed when you launch your offer. So you have to be long the company for 105 days. You have to be carrying the financing cost for your acquisition, which could be in the billions, for 105 days. That's expensive, especially when you don't know if you're going to get the benefit of your bargain. And so that added cost has really dried up the market for hostile takeover bids. And if you believe that hostile takeover bids have a place in creating efficiencies in our market by punishing lackadaisical boards, well, you shouldn't be in favor of that kind of change. But that's where we are.
Basically, go ahead, please.
When poison pills were a thing, would the acquired company not have to do that? Would they not have to be long the company for that long? Because you're saying the effect of the poison pill was to extend the hostile takeover time.
Yeah, you could negotiate, and maybe you could get struck down earlier. Maybe you could wheel and deal with there was always a chance that it wouldn't be 105 days, and typically it was only more like 70, 75 days. And so you had a lot more optionality, a lot more flexibility, and as a result, and people can talk themselves into things. You had to be open for 35 days under the old regime, at minimum, and maybe plus some unknown. And when it's plus some unknown, you can convince yourself that it's a good idea. When you know it's 105 and you can calculate it, and there's your spreadsheet, and there's your cost, it's just a different. Humans are humans. Humans are not good at risk. We work in risk markets, and humans have a bad approach to risk. We're not good at it at all. And people make poor decisions. If any of you is harboring the idea that we have enough, the efficient markets with rational actors and all that, none of that happens. That's not real. And so that's not how humans work. So that's my answer to that.
And from the acquirer's perspective, if you go out for 35 days and you don't get to where you want to get to because you haven't been able to come to a compromise with the board, or you just, you're done. You said 35 days, and if you don't want to proceed, you don't want to proceed. But if you have to go out and say, I'm going to keep this offer for 105 days, and you're legally bound by that, you just have way less flexibility. You're just putting yourselves out there for longer. And what would happen is when you went to seek the termination of the poison pill, you would make these arguments to say, listen, this company doesn't need 75 days because it already ran an auction process, and it's talked to all, no one else wants this company, and we're the only savior for this target company. You have to let us get to the shareholders. And you could make compelling arguments to kind of narrow down that time frame depending on your facts and circumstances. And so this is just a little bit more fun for us. And then
Yeah, it was the greatest part of the practice. I absolutely loved it. It's gone, and I'm sad. As soon as in British Columbia, we have a thing called advanced notice policies now, which if you're going to put and these have only been around since 2013, 2014?
Sure.
The advanced notice policies say that if you're going to put a resolution to the shareholders of a company, you have to give them advance notice of it, which basically means you can't ambush a company on its AGM. And ambushing a company at an AGM was, again, one of my favorite parts of the practice. It was just so much fun. It's just gone now. It's just gone.
Yeah.
Commercial agreements?
Yeah, commercial agreements. Anything else on M&A? Any other M&A questions? Okay. So both Steve and I have experience with commercial agreements. And what ends up happening in our practice, as I mentioned before, public companies have a need to have their external counsel advise them regularly on all of their, securities law compliance. And as you get integrated and get to know that business, it's a good opportunity to do other things, be value add to your clients in other ways, and that often leads you down the path of doing some commercial arrangements. So we've listed a couple of here, and this morning was a great example. I was on, just getting back to the day in the life thing, I was on call with a client who they're a public company. I advise them on all their public company work, but they don't have an in-house lawyer, so we were hashing through, they're in negotiations with actually like a government body and a commercial party on an offtake agreement / joint venture agreement. And so it's very tense and tricky because you're dealing with a government that isn't always a commercially predictable actor. And we were talking about timing. I was like, I've got to go to UBC and talk about what it's like to be as a securities lawyer. And everyone just on the phone universally laughed because they're like, how can you say what a particular day is? Like, we call you with a different problem every day. Anyway, so joint ventures, these are a nice way for companies to dip their toe in a partnership of some sort. I actually find joint venture agreements or shareholders agreements, anything where there's ongoing obligations, are actually kind of one of the most challenging types of work that we do. I think when you're doing corporate finance, or even when you're in an acquisition, the playbook is a little bit more obvious, and the end game is a little bit more obvious, and there is an end point, like you sell the company at some point and then you move on. But when you have the commercial arrangements, like joint venture agreements, when you're trying to talk about how the parties are going to work together going forward on the long-term basis, it really requires some deep and thoughtful thinking. It really requires you to understand what the client's commercial goals is and what the parties are trying to achieve. And then you have to kind of play out all the different scenarios that you can think of that you think is appropriate to include in the agreement. How are the parties going to work together? And when are they able to stop working together? What are, penalties? What are bonuses? There's a million different things that can go into negotiating these types of arrangements. And so that's another area where, I think you can be a strategic thinker and really add value to your clients. These are also the agreements that when they get dusted off 10 years after you worked on them and someone's like, what did that mean? And why does it happen when this thing happened that you didn't talk about at all in the agreement? It's also very terrifying and it can be challenging, but yeah, we've all gone back to agreements written in the 1990s, and I haven't been practicing that long, so I didn't draft those, where the parties just, the world looked different. They weren't sure if they were going to actually be in effect. Maybe they were entering into 100 different joint ventures and they didn't put a lot of time. They just followed the template and moved on, and then you're trying to apply that to an entirely different situation. So that's just an aspect of.
One of my clients in the forestry sector has a joint venture agreement since 1993, I think it was, 92, drafted by Hamish Cameron, who was at Bullhauser, which is now Norton Rose. And Hamish was one of the sort of grandfathers of corporate law in British Columbia. Everyone looked up to Hamish. And we're now representing our client in litigation over the interpretation of that agreement. And I was on a call with them where they were all going, well, how the heck could they draft it like this? It's nonsensical, et cetera, et cetera. And I'm like, guys, it's lasted 30 years. 30 years you've run a corporate relationship, and this is the first time you had a dispute. I think that is the gold standard of joint venture agreements. Even if you think it's crap now, it lasted 30 years. And I can only hope to have a joint venture agreement that I draft have no problems in it for 30 straight years. Mind you, this one section is quite gobbledygook. I don't understand what he's saying there. But I'm not throwing Hamish under the bus. There's other types of securities law advice that we get into. We're running out of time here, so I'm not going to go into a bunch of stuff. But you talk about governance, you talk about compliance, protection of minority shareholders, a bunch of rules around that. Proxy fights, when you got an activist shareholder who wants to make changes, and so you start fighting about what's going to happen at the board. There's registration rules. That's when, if you're an investment dealer or a professional dealing with securities in the marketplace, that's its whole world into itself. We tend to just ship that off to our colleagues in Toronto because it's an area you can get a lot of trouble in if you try to dabble in it. Compliance with all the rules. You get questions all the time about compliance with exchange rules, compliance with securities laws. Equity incentive plans. Huge reason why people go public, especially in the tech world, is to be able to incentivize their employees with options that allow the employees to participate in the upside of this explosive growth company that you've set up. And then the explosive growth stops and the option plans ends up being an albatross around your neck. All of those things are stuff we deal with. The securities laws, there's a lot of them. If you have them in paper, there's about 7,000 pages of them. But you don't use them on paper. You look at the BC Securities Commission's website.
I look at them on paper, but.
I look at the BC Securities. Well, they update them, and so they're in real time updated. You never have to worry about some change you didn't know. And that's it. Our practices are. Our practices are a little different than a lot of people because a lot of the stuff that we do, they've hired us because it's unusual, it's weird, it's an exception to the boilerplate transaction. I don't mind saying we're expensive because you're hiring something for it. We're the people you hire when it's hard. And that's the kind of work I like doing. That's the kind of work I want to do. I want that work to come to us. And so, and I think we do a good job, and so we convince the clients it's worthwhile. But we do a ton of stuff. We do all sorts of things we didn't even talk about today. I was dealing with an insolvency over the weekend, which I hate insolvencies. Everyone's so angry.
On the topic of fees, we also are very creative and flexible when we're working with early stage companies, particularly in Vancouver. Like you have
of course.
Market. Just because we're being recorded, I wanted to make sure that that's clear.
No apologies.
In thinking about, this isn't a pitch for securities law or any particular practice, but just in thinking about what I didn't know in your seat. Like I think one of the things I like about our practice is it is technical. Like we're lawyers. We were both, geeked out in law school, right? Like it's good stuff. There's a technical aspect, but there's also a lot of opportunity to be strategic and creative. And like Steve said, it's not just the cookie cutter stuff that we're rolling out here. It's, it's problem solving. It's strategic thinking. It's integrating yourself into your client's business, getting to know how different businesses work. And so I think that is really what is most engaging about the work we do. So when I think about, I mean, I kind of fell into the practice, but I think that's kind of what's the reason I've been able to do it for 20 years and be like, wow, I haven't had a single day that's been the same as the one before.
It'd be nice sometimes.
I wish sometimes, but.
That's it.
Questions, comments? Okay. Yeah.
Thank you so much for sharing and all the process pieces. I have two questions. First question is about the clientele of the practice, like how many of the clients you serve are domestic companies in Canada or companies maybe established in Delaware or in Canada? The second question is how do you leverage your US experience in the context of Canadian
I don't really use my U.S. I don't hold myself out as a U.S. securities lawyer anymore. I got the credentials. I passed the damn test. I am certainly not giving up my call there, but I don't market that. One, because our firm doesn't practice U.S. law, and there's strategic reasons for that. But two, it's really hard to dabble. And to stay up to date on an entire other jurisdiction's entire set of laws, which are constantly changing, just like your own jurisdictions, trying to stay on top of two sets of laws, that's hard. And so I don't think I'd be doing my clients any favors by trying to practice a law straddling the border like that. But what it does do, and I'm sure this is the same for Susan as well, is it demonstrates credentials to your clients because they know that you have substantial experience in the largest capital market in the world. And as a result, they feel comfortable that they're talking to a person who kind of can walk the walk. And so while they don't expect you to still know exactly what the well-known seasoned issuer rules are for the SEC, they do expect you to know that that's a thing like that, and that you ought to be able to interface well with the U.S. market. My own practice, I would guess, and it varies year by year, but I would guess my practice is about 40% offshore, 60% onshore. That's a bit of a guess, though.
Yeah, same. I think. The U.S. experience definitely helps understand helps other lawyers and clients understand what training you had. Like you were in, there's a very specific environment in working in like a downtown New York firm or like a Wall Street firm, and they know that you have those battle scars. And it also helps you credibly understand and work with U.S. counsel, because every people ask, well, how many deals are cross-border? Like, oh, every deal is cross-border. There's always going to be some aspect to some other jurisdiction, almost always. There's just, there's lots of gems in Canada, and there's lots of people that want to invest into Canada. And then if you're in Canada, you have a successful business, you're going south and east and west, right? If you're going to expand. So there's an international aspect to most transactions. And so, maintaining contacts and, understanding how regimes in different regimes work is super useful in helping actually execute and identify issues at an early stage.
I wouldn't say many of our clients are Delaware companies, though. It's not because no one's asking us to opine on foreign law. Our clients come from all sorts of places. They may have a Delaware entity in their structure, but that's kind of a secondary thing. What you really care about is where their headquarters are. Go ahead.
Yeah, I also had a question about the sensitivity of practicing securities law, like its sensitivity to business cycles. So like we had COVID-19, and then now we're slowly moving out of COVID-19. So how does the nature of your work change as the economy also changes?
Yeah, I think, personally, I have a natural hedge because I'm not tied to an industry and I'm not tied to a type of transaction. I think, as we mentioned, in 2021, we were all the rage. I had a bunch of IPO mandates, so did Steve. Some of them happened, some of them didn't. But you can be damn sure IPO was the first word on my bio in 2021, 2022. And then maybe now it's restructuring. So I think with business transactions, because we're not industry specific, I think it means two things. It means you can try, you can try to stay busy because you can pivot to what's happening at the time. But it means that you have to have a broad skill set. Like, it's taking me a long time. Like, there was a period of time where I did a bunch of venture work because that was what was available and that was what was interesting. If the capital markets pick up, like, we'll be doing a lot more bought deals and prospectus offerings. And so, unfortunately, right now, you'll probably see, I did an insolvency in 2020 that, like, was the most challenging deal I've ever done. I know, Steve, you've done a couple of insolvency. They're tough transactions. So it absolutely affects our day-to-day depending on what's going on with the market. But I like to be busy, so that's why I try to do it all sometimes.
Yeah, there's a lot of lawyers that will hold themselves out as being a tech lawyer or a forestry lawyer or a mining lawyer, et cetera. And that's all stuff you can be. I'm not denigrating it. But if you tie yourself to an industry, you're tied to the industry. And Susan and I are securities lawyers. Go ahead.
You want to go there?
Someone's got to go first.
Thank you. How's your work-life balance?
That's an interesting question. You want to go first or you want me to?
Depends on the day.
Yeah. I have been married 30 years. I have a spouse who is very happily a stay-at-home mom. And I got to tell you, that has been an invaluable resource for me because there were stretches when my kids were young where I thought I was being a pretty shitty dad. Just because the demands of the job were such that I had kids before I went to the States. And when I was working in the States, a large chunk of what I did was sovereign debt. And so and this is before the day of electronic data room. So I was fairly junior, so I was flying to Argentina to read a data room. I was flying to Qatar. I was flying to Israel. I was just constantly on planes. And so, which is really not a great life. And so my work-life balance wasn't great then. But it's up to you to determine what you're going to do with the time that you've got. And so I made a conscious decision when I came back to Canada. It's one of the reasons I left the States, was to be able to concentrate more on my kids. But it was a huge benefit that I spent those years down there, because I was an 8th year associate when I left, because I had those battle scars that Susan was referring to, which really made me credible in the marketplace. And in Vancouver, I had a slightly better balance in terms of hours, but my balance was just like crazy offside when I was in the U.S. But I loved it, and that's the thing. Because, people don't really go to a concert pianist and ask them how their work-life balance is, because they view being a concert pianist as something that's worthy in and of itself, and therefore it's something that you kind of understand that you might make sacrifices in order to achieve being first violinist in an orchestra. It's kind of what you're doing when you're a lawyer. If you want to be really good at law, it's an incredibly enjoyable thing to do. There's a lot of personal growth and a personal satisfaction from doing the job. And if you want to be really good at it, you need to lean in. It's as hard to get, our job, there's maybe 30 people to do what you and I do in this city, 30, out of 14,000 lawyers. And so if you want to have one of those chairs, it's harder to get than being first violin at the VSO. So it's your choice where you want to land. There's no right way to practice law, and there's no right way to be a securities lawyer. You can do anything you want. But if you want to shoot for that chair, it does take time and effort, and there's no way around that. But one caveat, my youngest daughter is in law school right now, so I couldn't have been that shitty a dad.
So I'm in a dual lawyer household. And I think a couple things about the way we practice. When you're more junior, you are more reactive, you have less control over, you have less understanding, and you have less control over what your schedule is going to be. Because the type of work you're going to do is going to be a bit more of a grind. You're not going to be sitting in front of a board like holding court, right? Like you've got to get into the trenches and really learn, and that takes time, like Steve was saying. I think that we travel way less for work than we used to. Like I spent 6 weeks in a data room in Brussels doing the Belgacom IPO due diligence in 2000 whatever.
We don't
but
say the dates
that
anymore.
doesn't like that's not going to happen today, right?
Yeah.
You're going to be in your home in your pajamas. You're still going to be doing the work. So So there's more flexibility there, for better or for worse. I mean, we can all debate the pros and cons of it. I think that balance is really not something that, whatever job you have, it's going to take as much from you as you're willing to give it, whether that's working in private practice or whether that's being in-house or whether that's being a professor at a law school. Like, I see, like, one of the hardest working person in our firm is probably the director of professional development, because she takes, like, Jen McNaught, you guys all know her, right? Like, Jen works freaking hard because she thinks carefully about every single decision because she puts everything into her job. And, you know, you can't do this job well without it taking time and hard work. But I think, you know, I see it with people. There's a lot of misconceptions about what private practice is. I think the thing about what our practice is you're being reactive to clients' needs. And so that can be very inconvenient when you're planning spring break and someone's launching a bought deal. But we work in teams. I don't work on anything without anything significant without another partner, so that we are always tag teaming. And that's kind of, as you get more senior, my I don't know if I want to call it balance, but, you know, my life satisfaction is, you know, gets better the more senior I get, and the more I can build my team, and the more I can build relationships with the client and manage those various commitments.
But anyone who tells you it's easy at the beginning is lying to you. Yeah, and that's just part of the deal. If you want to do it, that's great. If you don't want to do it, that's great too. There's lots of ways to practice law. The hardest working, least life-work balance I've ever seen of anyone is my father-in-law. He was a social worker, and he ran a office in New Westminster, which is where most people, when they first come out of prison, are placed in the Lower Mainland. Nobody's had a worse work-life balance than him.
You had a question?
Yeah, thank you, Susan and Susan, for sharing today. So I do have two questions. The first one relating to the IPO. I want to know whether for the typical Canadian IPO, do we work together with the US lawyers? It's like normally there will be some US like legal secrecy law issue like Reg S, 144A, that sort of questions. So would you work with them to address that? Second thing is about like the practice, because we do top 5. M&A, commercial agreement, and also general advice. To me, it's really comprehensive, because back in my home jurisdiction, like the lawyers, they just focus on one or two of these areas. And therefore, I just want to know, from your perspective, how to get prepared for, if I want to practice here, like do you advise to read the listing rules of the takeover code starting from there, or something that we can get prepared before to work in Canada?
So taking your second question first, it's bad luck that you're talking to Steve and I, because we have particularly diverse practices. We do have colleagues that have much more focused solely capital markets practices, and we have colleagues that will say, I am a private equity lawyer, full stop. I think part of the reason that because of the breadth of our practice is, you know, the background and what we enjoy about the job. It's also being reactive to the Vancouver market, because when you're in Vancouver, if you are working with Vancouver-based clients or even some Canadian-based clients, they either have no legal team or a small legal team. And so you end up playing a bigger role with that client. Whereas if you're in a larger market, it would be way easier to just say, I'm just a capital markets lawyer. And we do have like colleagues in Toronto that are much more specialized. So that's, I don't know what you
Yeah, I think that's exactly right. Just speaking for myself, the kind of stuff I like to do for my clients is the high-level mission-critical advice. I get the most job satisfaction from that. And if you want to have lots of opportunities to do those things, you have to have a very broad base of clients, because those things don't happen very often in each individual company's life cycle. And so if you want to have that stuff happening and crossing your desk a lot, you have a lot of clients. We don't have a massive corporate base here in Vancouver. And so if you want to have a big base of clients in Vancouver, you've got to cross industries. And so both of us are on some lists of best mining lawyers in the country. I'm not a mining lawyer. Are you a mining lawyer? No. Oh yes, unless you need a mining lawyer. And then I'll point out that we are both on the best list of best mining lawyers in the country. Just because you were in Vancouver and there's lots of mining companies, we do a ton of mining work. And we definitely know that stuff. But it's mostly about, it's a marketing question, but it's also a self-satisfaction question. I don't want to be in that box. I want to do all sorts of different things. I also know some of my own failings. I have an 18-month extension span at most, and I'm really bored of companies after about 18 months. And so I need transactions. I need things crossed my desk.
For your existing clients.
Except my existing clients, and my existing clients know my failings. I chat with them about it. But being open and honest is an important part of the job. So in order for me to have job satisfaction, I've got to have a broad base, otherwise I'm just not happy.
And the answer to your first question is yes.
Oh, and stuff to read, it's really hard. It's not, there's nothing I can point you to, really. Take all the classes, but you know what? I didn't take securities law in law school. Yeah. My best class, most applicable class to my securities law career is evidence. Yeah, because if you think about it, what a solicitor does all day is make evidence. So you should probably know how it's going to be interpreted. Anything else? We've gone over time. People have been peeking in the windows.
No, we got another 10 minutes at least.
Oh, okay. Sorry, I didn't realize we
I
had.
have a question.
Yeah, go ahead.
Yeah, so my question, it may not be specific to your practice at Blake's, given that you charge such high fees and such prestigious clientele. But just a question maybe for students in the room who are thinking about practicing securities law, maybe at Blake's, but not necessarily Blake's, maybe at a smaller firm, maybe at a smaller practice. On the financing side, could you speak a little to some of the differences between, say like a jurisdiction like the United States or the UK, given that you guys have experience there, versus Canada and Vancouver specifically? And what I'm kind of alluding to is like one of my observations about the market here is that the Canadian securities markets are characterized by a very large number of very, very, very small public companies, which is kind of one of the big differences I've noticed between the Canadian market and the US market. So like in Canada, you'll have this phenomenon of, sort of companies that would be getting, if they're a US company, they'd be like getting seed financing. And here they'll like do an IPO.
Right.
Like on the CSE or something like that. And so I don't know if your practice, dips into that world at all, but I know for a lot of lawyers in Vancouver it does. So I was just wondering if you could speak a little about that. Is there a big difference in kind of representing those companies, or is it different lawyers that represent those companies? Like, how does that work?
The legal issues are the same. You're doing an offering. The same rules apply to all of them. The economics and the practical realities are very different. And so one of the good things about working on larger files is that you've got a big budget, and as a percentage of the offering, your budget is minuscule as compared to the size of the transaction. And so you can spend your time to dig down into every rabbit hole. On smaller deals, you can't do that. And of course, that characterizes as part of our own practice. We're in Vancouver. There are smaller deals that cross our desk. I don't do any CSE work. I have one VSE client, TSX client. Sorry, I'm very much dating myself there. The VSE hasn't existed in 25 years. Because I'm slightly older than Susan. I don't do a lot of that. And just the practical reality, I think, is that...
So just from like a person, so like your clients, it's mostly TSX clients then?
TSX or other stuff.
Venture clients.
Yeah.
Okay, so.
It's different. It's a different world.
You've got to be very economical on how you approach the files. Like there's only so much money moving around, and so you've got to be incredibly efficient about how you do it. A lot of the successful shops that have those big books of that business work on a portfolio model, and they'll have very precedents they very much stick to. They're not really interested in anybody who has some novel way they want to vary. If you're only raising $2 million, you got to do it exactly the way you did it last time. Otherwise, the costs just don't make any sense.
It's a big, like those types of companies bearing the public company costs. Sometimes they regret it, right? Like, there is a kind of small cap investor base in Canada and in Vancouver in particular that people want to access, but it is expensive, and it's sometimes painful from a compliance perspective. The TSXV rules are way more prescriptive than the TSX rules, and so you end up having the exchange come in and kind of really do a deeper dive in your compliance and, you know, have different, more onerous requirements. I think that the transaction that you see, like kind of like the Vancouver special going public transaction is the RTO onto the TSXV, right? So you have a shell company, either an actual CPC that the TSXV sets up, or if you set up under the CPC program, or a shell company that used to own an asset that isn't doing much anymore. And so what happens is you've got a public company and you meet the public float requirements, which means you have the right number of shareholders to be listed on the exchange, but you don't have an operating business, and so you have the public company go find an actual operating business, and you do an M&A transaction, but the purpose of the M&A transaction is actually to take the company public. And so those require extensive disclosure. Usually the target company doesn't have the right financial statements, so you end up having a bunch of work there. So they're labor intensive, but it's a very common type of transaction that you see in the small market. And so when SPACs were a thing, the first time someone explained to SPAC to me, I was like, well, we've been doing, this is just a CPC or an RTO transaction, which is just a lot more money, writing a lot bigger check. So
They're actually worse because the money in a SPAC is completely illusory because everyone has a retraction right on the closing, which you don't necessarily on a qualifying transaction for CPC.
did I kind of get it, what you were thinking?
Yeah.
It's an interesting marketplace in Vancouver because there's so many people that make their money from facilitating those transactions, and that you get a lot of them. And the investors expect liquidity much earlier in the life cycle of a company than they do in other jurisdictions. And so people have less appetite for trapped money in BC than they have in the US.
Yeah.
Yeah, I was just curious because you both alluded to your experience in the US or the UK. So, like, if your ultimate goal is to be a securities lawyer in Vancouver, how helpful or necessary do you think having that experience?
It's a balancing act. Like when you go afield, you develop a massive skill set because you have all sorts of varied and interesting stuff crossing your desk, and you see all sorts of market participants that you may not see just working in Vancouver. However, if you want to be a successful securities lawyer in this market, all law is local and all law is based on successful lawyers and law practices. It's based on relationships. And if you go away for 8 years to get that great skill set and come back, there's somebody who's been working here for that 8 years, which has almost as good a skill set and knows everybody in the city, and you're competing with them. I like what I did. I don't regret it at all, but I can see that there's give and take.
It's certainly not necessary,
No.
but you have an opportunity, like, take it. The law's not really here.
That is also a thing. I think a lot of young folks feel like they get driven into channels very quickly in their career, and they feel like it's almost impossible to switch courses. You can switch courses, change things. You got some momentary pain. You have to step back 12 months on your progression, whatever. Just do it. If you're going to be happier, you should be happier.
Become a law.
There you go. Exactly. Become a law professor. I'm on my 4th law firm. It's you can switch things up. It's easy. Just get up and walk. I haven't done that in 15 years, and I have no intention of ever doing it again.
The fees, firm, what is going on?
I'm not in sales mode. I'm just talking what it's like to be a securities lawyer.
That's true. Okay.
Go ahead.
Points you find that your practice may like change maybe from more general corporate law to being an associate and then you specialize more as you became more senior?
I think I might probably got more broad as I became more experienced and do more things.
Yeah, if you just think about your experience is just the number of times a thing has crossed your desk. When you're a securities lawyer, the core stuff that you do is finance and M&A, and so that's the majority of things that cross your desk. So when you're junior, that's where your skill set starts to grow. But as you get more senior, you do more stuff, and so you start doing more stuff. Weird things happen to your clients.
Any last questions? If not, let's give a round of applause to